Hi, my name is Jiaxuan. Sexual offense is a subject of frequent concern in criminal law, it including rape and sexual assault. In this video, we are going to focus on the area of rape in Malaysia. First of all, what is rape? Rape is referred to as a male forcefully having sexual intercourse by inserting his penis into a female's vagina without a valid consent. In Malaysia, the law on rape is dealt under Section 375 and 376 of the Malaysian Penal Code. Under Section 375, it defines that rape is said committed by a man who has sexual intercourse with a woman against her will or without her consent. With her consent is obtained by putting her in fear of death or hurt, or by using a position of authority, a professional relationship, or other relationship of trust, or at the time of giving such consent, she is unable to understand the nature and the consequences of what she is consenting to, as well as with or without her consent, when she is under 16 years of age, which is known as statutory rape. According to Section 376, the punishment for the offense of rape is provided for with imprisonment for a term up to 20 years with whipping. Basically, the law on rape in Malaysia strictly retains the legal definition under Section 375 of the Penal Code with statutory exception. Sexual intercourse by a man with his own wife provides for that definition. It is undoubtedly the rape law in Malaysia provides the area for the offense of rape to be prosecuted, but raise the unjust circumstances for both the victim as well as the accused. Accordingly, the law on rape in Malaysia is deemed to have a need of improvement and reformation. I will now pass on to my teammates to discuss about the areas that need to be improved in the law on rape in Malaysia. Firstly, Chao will talk about the first two areas that require to be improved, which are gender-specific offense and vaginal intercourse.
Hi, my name is Teo Chao. My student ID is 0339870. Under Section 374 of the Penal Code, the offense of rape is a gender-specific offense. The definition of rape under Section 375 is still based on a binary gender concept where male is perpetrator and female is the victim. Some offenses in Penal Code are expressed as gender-specific, but in substance or functionally they are not. For example, infanticide is defined to mean a homicide by the woman of a newly born child. In fact, it is homicide in essence. Just because the killer is the mother, it can be considered as a homicide caused by diminished responsibility due to postpartum depression. Similarly, regardless of the gender of the victim, the essence of non-consensual sexual intercourse is rape. Just because the victim is a male, it is sexually discriminated to prosecute under other provisions such as Section 371A, which criminalizes anal or oral sexual intercourse by penis as carnal intercourse against the order of nature. This is because Section 371A is not an accurate legal justification for criminalizing sexual assaults that violates the bodily integrity of an individual, since it artificially distinguishes between heterosexual and non-heterosexual sexual assault. Therefore, it leads to the notion that heterosexual assault is rape, while homosexual assault is a less serious crime. Moreover, Section 375 excludes female perpetrators. There is only a very limited scope for female perpetrators to commit sexual offences, namely sexual connection by object and etc. under Section 377CA by introducing an object or any part of the body into the vagina or anus of the other persons without that person's consent. Although the maximum sentence for this offence is the same as for rape, the latter is likely to be seen as less serious than Section 377A because of the terminology. Section 375 also does not view instances of sexual assault on the body of a transgender person as constituting an act of rape. However, it allows a male who has undergone gender reassignment surgery and then become a female to be legally recognized as a victim of rape as long as the transgender person seeks a declaration before the court that he had changed his gender. Obviously, a transgender person who takes a hormone treatment without undergoing gender reassignment surgery can hardly be regarded as male or female in law. Section 10 of the Penal Code is silent on this issue. Besides, the offense of rape in Section 375 is limited to vaginal sexual intercourse with the perpetrator's penis, discussing back to the point that a male who has not undergone gender reassignment surgery cannot be a victim of rape, and the reason is that he has no vagina. The law does not stipulate the vagina should be natural or surgically constructed in committing rape, because Lord Justice Wilmer mentioned in the case of SY and SY that it will be observed if a female with artificial vagina is not protected by criminal law to a great extent, because she is legally incapable of being a victim of rape. Even though Section 375 does not express unambiguously like the Singaporean Penal Code, it is clear that rape offences in Malaysia must be penal vaginal intercourse. This archaic, rigid, and technical element of the offence is emphasized again in Punya Anak Jalop against public prosecutor. In this case, the appellant who had impregnated the victim was acquitted by the Court of Appeal because the prosecutor failed to prove beyond reasonable doubt that the penetration of the vagina was done by penis rather than fingers. It is thus obvious that in the concept of rape, the possibility of pregnancy is not overriding. Since the pregnancy argument lost credibility, there is no reason why Section 375 should not be expanded to include other kinds of sexual intercourse, that is, anal and oral. Some jurisdictions, for example the Washington state in the United States, have adopted gender-neutral legislation that acknowledges male victim of rape but also recognizes the female can commit rape. To achieve gender neutrality, jurisdictions have adopted a broad concept of sexual intercourse which involves vaginal, anal, and oral intercourse by any penetration. Other jurisdictions such as England and Wales broaden the scope of rape to include male victims but not female as principal perpetrators. In short, it is not important to determine the gender of the victim or the kind of sexual intercourse, but the issue is whether the victim is forced to have non-consensual sexual intercourse. I will now pass my time to Shakira to talk about circumstances making sexual intercourse rape as the next area of rape law in Malaysia that is in need of an improvement.
Hi, my name is Shakira. Under Section 375 of the Malaysian Penal Code, it is clear that consent is a central issue in the offence of rape. Unlike the English law, the Malaysian law's definition of rape in regards to circumstances is very specific. We submit that, although these provisions prove useful, it may cause confusion and may not even be necessary. For example, in paragraph F, this provision has gained the attention of many non-governmental organizations protecting women as they strive to protect the women's safety in their workplaces. However, this may not even be necessary if we try to look at the English law. Looking at the English law, which has developed for longer than the Malaysian law, it would be more convenient if the definition of consent was consolidated under just one provision. We are not alone in pushing for a better law for the offence of rape in terms of the definition of consent. One of the many common law countries who are on the same road with us is Ireland. One of Irish academics, in her article, suggests that the changes made in the English law should be considered seriously as many of our laws were adopted from them. Hence, any development in the English law followed by recent case laws could be paving a way for us toward a better law. In the article, the proposal to the Irish law suggests that the primary requirements for a legally valid consent to sexual intercourse are first, voluntariness, second, capacity, and third, knowledge of relevant facts. It is submitted that these three elements would also cover Section 375 of the Malaysian Penal Code. Not only that, the definition proposed here could also be equally applied to other non-consensual sexual offences against adults. Indeed, in England, this is precisely what has happened, and it is envisaged that a similar approach should apply in Ireland and our country, Malaysia. The first requirement, which is voluntariness, means that the consent must be given freely, and when there is violence or threat of violence, to attain consent, this will not be considered as free. This requirement would cover paragraph A, paragraph B, and paragraph C, which mainly talks about the victim's will or consent and threat of violence. Voluntariness should also cover paragraph F, as a threat of adverse consequence was sufficient to vitiate an apparent consent. The second requirement, which is capacity, requires an individual to have attained the legal age of consent, and this would obviously cover paragraph G, which specifies that consent does not matter when the victim is under 16 years old. Finally, the last requirement, which is the requirement of knowledge of relevant facts, obviously requires that the complainant should have had all the knowledge or relevant information, and if her consent has been procured as a result of fundamental deceit, the consent would be considered invalid. This should cover paragraph C, paragraph D, paragraph E, and paragraph F, which talks about the identity of the perpetrator, misconception, and also understanding of the nature of the act. Now, I will pass my time to Zinlin to talk about statutory rape. Thank you.
I'm Lee Zenling. I will be presenting on statutory rape, which is ruled under Section 375 in Malaysian Penal Code. This is a circumstance where the man had sexual intercourse with a woman with or without her consent when she is under 16 years of age. Statutory rape, which is part of common law, originated from England, aimed to protect girls from being taken advantages of adults due to their tender age. In addition, it was a worrying social phenomenon when the girls preferred a sexual relationship with the adults. It also intended to avoid unwanted early pregnancy among teenagers. In the United States, the late 19th century, after the campaign launched by Women's Christian Temperance Union and other similar groups, the age of consent was increased as high as 21 years old to give more protection to girls from sexual aggression. And that was how statutory rape, from which Malaysia Penal Code originates. In Malaysia, the age of consent in sexual intercourse is 16 years old, where the law deems that girls under 16 are incapable of giving consent. In other words, consent in sexual intercourse is immaterial for girls under 16 years old. However, the law of consent seems to be inconsistent because even though a person who had reached the age of 18 is not considered as a child, they are not yet allowed to take part in general elections unless they reach the age of 21. However, their consent is not applicable in sexual intercourse context where she is a girl under the age of 16. Looking to Section 90, subsection C of the Penal Code, the general rules provides that a person below the age of 12 is unable to consent to anything. Following these different ages, there is no clear interpretation to the law of consent and age. For instance, a 17-year-old girl could consent to a sexual intercourse with a man as she is above 16, but she cannot consent to sexual assault under Section 14 of Sexual Offences Against Children Act 2017 because she is below 18. This section provides that any other person who, for sexual purposes, touches any part of a child's body, make a child touch any part of the body of such person or any other person, makes a child touch any part of the child's own body, or does any other acts that involve physical contact with a child without sexual intercourse would be liable to commit an offense. It becomes a confusion when the law allows a man to have sexual intercourse with a 17-year-old girl, but at the same time does not allow him to touch any part of her body. Another notable matter to look at is Romeo and Juliet law's applicability in Malaysia, where young lovers can legally consent to sexual intercourse. This law is common in the United States, which occurred among teenagers for close-in-age exemptions. For instance, when a man has consensual sexual intercourse with a girl below 17, but at least 14 years old, this may be statutory rape, but the man need not register as sex offender provided that the age gap between them is not more than 3 years. Looking back to Malaysia, this law could be a problem because we do not have a sex offender register. Hence, the statutory rape in Malaysia needs a clear reformations and clarifications in regards to the age and consent in sexual intercourse. Reconsidering one's age when consenting to sexual intercourse, it seems to be crucial, and making an amendment to the age of consent is necessary in order to provide a better law in this matter. The suggestion to insert the provision to resolve with consent for underage sex when the perpetrator's age is not very much older than the victim's age would also be a good point to improvise the law on offense of rape. In addition, it also needs to be interactive and in tandem with current issues and globalization in this new era. The law is hoped to play an active role in ensuring the safety, peace and harmony of society. Now, Esther will continue to present further regarding two areas of Malaysia's law on rape, which requires improvements, namely marital rape as well as the mental element.
Hi, I'm Esther Tang and my student ID is 0339714. The exception to Section 375 provides that it is not rape if the woman is the wife of the perpetrator. This is based on the patriarchal doctrine, which can be traced back to the English common law asserted by Sir Matthew Hale in 1736, that a man cannot rape his wife. The basis of this rule was that within the institution of marriage, there was an irrevocable consent to sexual intercourse, granting the husband a license to rape. This described women as mere shadows of their husbands at best and as the property of their husbands at worst. Hence, rape in Malaysia is only recognized in non-marital circumstances. In light of recognition of the rights of women and societal development, many countries that inherited British law have abolished this section, but Malaysia slavishly adheres to a law that is exceedingly outdated. In the United Kingdom, the House of Lords in the case of Crown against R made it clear that marital assumption had no place in modern law and ended its reign. Marital assumption under English law was no more. Singapore has fully repealed their marital assumptions from their penal code in May 2019. It is submitted that the law in Malaysia should be the same as well. If the penal code had a proper definition of consent, it would be much easier for the court to determine whether the sexual intercourse was rape or not. Consent cannot be implied from an event that occurred some time ago. The victim who agreed to be lawfully married to the perpetrator does not mean she consented to sexual intercourse at any point of time in the relationship. Further, since the perpetrator is known, rape within marriage causes the victim considerable continuous suffering and should be categorized as a crime. Relating to the mental element, the elements needed to establish the mental state of mind of the perpetrator in Section 375 are unclear. Section 375 does not mention the mental state of mind of the accused in general, although subsections C and D make some reference to it. While it is clear that the sexual intercourse must be carried out intentionally, there is no requirement that the man has reason to believe or to know in the circumstances described in subsections A to G. In Singapore and India similarly, the law does not make any express reference to the state of mind of the accused. On the other hand, the Sexual Offences Act 2003 under English law explicitly addresses the mental state of mind of the accused. The accused must not have had a reasonable belief that consent had been given. In the case of PP against Teo Ing Chan, it is commented that if a man had sexual intercourse with the woman, believing that she was consenting to the act when she was in fact not, he can rely on the exception of mistake of fact found in Section 79 of the Malaysian Penal Code to be acquitted of the charge of rape, even though Section 375 of the Code is silent on the mens rea requirement for rape, and it is for him to show on the balance of probabilities that he made a mistake and that he did so with good faith. This in turn requires recourse to Section 52, which involves due care and attention. Nevertheless, it is submitted that in Section 375, there is still a necessity to explicitly provide for the mental state of mind of the accused. If the mental element is included in Section 375, the prosecution, rather than the accused, bears the burden of proof. The most appropriate mental state of mind, mental element is that set out under 11C of the English Sexual Offences Act 2003, which states that the accused must not have had reasonable belief that the victim consented to the sexual intercourse. This suggests that even though there was no consent present, but it was reasonable for the accused to believe there was, it will be enough to acquit him if he believed there was consent. In summary, the proposal for reform regarding marital rape is the exception to Section 375 should be deleted, and for the mental element, Section 375 should explicitly include the mental state of mind of the perpetrator. Moving on, Jiaxue will conclude this discussion. Thank you.
In a nutshell, it could be summarized that, according to the law on rape, as provided under Section 375 of the Penal Code in Malaysia, the areas of gender-specific offence, statutory rape, vaginal intercourse, circumstances making sexual intercourse rape, marital rape, and mental element are the areas that need to be amended in the rape law in Malaysia. It is in fact that, accompanied by the occurrence of the rape in various forms, which is not identified in regards to the definition under the Penal Code, and the needs to protect the potential victims, as well as the needs to deter the possible perpetrator from evading due punishment. There is still much to be improved and updated, since the current rape law in Malaysia is insufficient in covering the other circumstances of the rape which are not identified in the Penal Code. Accordingly, it is suggested that the law on rape should not be limited to the provisions under the Penal Code. This is the end of our video. Thank you.